And I want also you to look at people who have been arrested in Uganda, like Jamil Mukuru, for example, having led a certain rebellion group. And that person is not being taken to court-martial. And others who are civilians arrested on different offenses are taken in the court-martial. Don't you think that the High Court, with its well-qualified judges, can handle all matters except those which are so exceptional? But those exceptional cases should be given a section of how they become to be exceptional cases, to be tried in the court-martial. I want you to take us through that line. Thank you very much. Don't you think, Council, that International Criminal Division can as well handle matters like General Megira talked about, for example? Don't you think? Don't they have capacity to do that, in your wisdom? Can't you also take it?
My first concern was in regard to time management, because earlier on he had raised a red flag that probably would handle this very fast and join the others in the chamber. But, Mr. Chairman, sir, if that is the case, because really this memorandum is very elaborate, I want to thank Councillor Jude, with whom I studied at the law school. Thank you so much. It will really enrich us as a committee. But something small with me, because honorable members, in summary and in my understanding, this bill is dealing with civilians to be tried in the general court martial upon commission of certain offenses. But there is somewhere where you said, where you talked about the monopoly. Just on page 3, where you talked about of course, the monopoly of the defense forces in regard to the ammunitions. Now, honorable members and Mr. Chairman, in my understanding is that when a civilian is permitted by license to hold a firearm, once they commit an offense, they should be tried in the civilian court. That is my understanding. But when you hold it unlawfully, then you will be taken to the general court martial. Now, Council Jude somewhere is saying that there would be instances where a civilian who is holding it legally by license would be charged in the general court martial. If you can help me bring out those instances, if any. Thank you.
And I have colleagues who came in later.
As you realize, this whole conversation relates to one issue: trial of civilians in the military courts. That's the only controversy in my view. In my view. And I think if we can zero and have a real conversation about that, we might make progress on this. Let us look at what did this case say. 15, your clause 15 of your submission, the Kabaziguruka case. You see, it would be better, because you see there were several judgments. And when you just say the judgment said this, you know, you run the risk, which I see many members of the public, you know, running. This is the judgment, this is the judgment. we need to go to the specifics. Which judge said what on this particular point? Because if you do that, then you narrow the point of interrogation. What did the judgment say? And if we are implementing this judgment, what are the confines? So, as you do realize, many judges had different reasoning, though they came to the same conclusion. And you say the trials of civilians within the military courts, and I'm on page 7, should be only in very limited and exceptional cases. That's what you say. If we can't go just to the judgment itself, because we are going to interrogate those judgments and say, this is what exactly the judges say, or this particular judge said this on this. It will help us, other than having a general conversation, trial, civilians, trial. Number 2, I want you to help clarify on the principle of aiding and abetting. Assuming a soldier has committed a service offense under the UPDF Act, but has been aided and abetted by a civilian. Because the general principle you and me know about, if somebody aids and abets, is equally guilty like the principal offender. Do we have them tried parallel? The soldier being tried, if he has committed an offense under the what? The UPDF Act. Tried in the court martial, then this civilian who has aided and abetted goes to a civilian court. Do you have 2 parallel systems trying a person or different person on the set of the same facts? And I'm glad that Attorney General is here. He should consume this. He's not appearing, but he should consume it. There is a suggestion made by Jude in his presentation that other than using the word in consultation with the Judicial Service Commission, can we give the Judicial Service Commission some wider role in vetting the nominees by the High Command for this position? So that, because since we have not defined this consultation, what does it mean under the law? But if the High Command forwards the nominees to the Judicial Service Commission, and they are interrogated as to their capabilities and the appreciation of the law, since they are going to perform judicial functions, other than saying any consultation. I think this is, to me, it is a brilliant idea which we can consume to give the judicial service a more role in appointing judicial officers. And by the way, we need to understand this. It is not about civilians. The court martial should not be about civilians. Because even soldiers need justice. They need justice. And they should be tried professionally. So we are not here to protect interests of civilians. We are protecting interests of everybody who appears in the court martial. If we can, the Attorney General can really think about this and discuss it with his minister to say, can we have a wider role of the Judicial Service Commission other than any consultation? To me, I'm convinced actually that that is the way we should be moving, but we shall discuss it